Hello and welcome to the DFW Divorce Insider podcast, bringing you all of the news and information about family law that you need to know. I'm your host, Matthew Eitzen, and our guest today is a recurring guest and one of the name partners here at Duffy & Eitzen, my mother, Melinda Eitzen. How are you, Mom?
I'm great. I'm glad to be here.
So glad to have you here. So glad to have you back. Now, we've got a big headline topic for today. We are talking about mediation.
It's a great topic. I love mediating. I love mediating in two capacities. Sometimes I mediate as the mediator, where I am the head honcho mediator. And we also have Marilee Lewis in our office who mediates as the mediator. But I also attend mediation representing one of the parties.
Mm-hmm. So you've got a lot of experience and you've seen it from both sides.
Yeah, for 26 years.
Oh, wow. Oh, yes. Very extensive. So I think a good place to begin for those listeners who don't know is with the question, what is mediation exactly?
Great question. So mediation is a settlement process. It's a method of achieving settlement. And when you go to mediation, the mediator, you hire a mediator, they're neutral. And they're hired by both parties and their lawyers. And the mediator is a facilitator, not a decision maker. And typically, we would be caucus style, which means one lawyer and their client is in one conference room. The other lawyer and their client is in another conference room. And the mediator goes back and forth all day, back and forth. And what they're doing is they're helping facilitate settlement. So when I'm the mediator, I'm not just carrying the water back and forth, just saying, what do you want and carrying it across. Because I've been doing this so long, litigating, mediating, collaborating, I've seen a lot of deals struck. So I'm bringing all that experience, and hopefully any good mediator is, to both rooms and helping them brainstorm. So we're all brainstorming all day to try to come up with a settlement offer, to a settlement agreement that they can both live with.
Mm-hmm. So you say it's a settlement process. How does mediation fit into the more quote-unquote traditional sort of style of litigated divorce? And how does it relate to collaborative divorce, which is the other common settlement style, that at least that I'm familiar with?
Oh, great question. So litigation and collaborative are both ways of getting divorced. And in either model, you can have mediation as part of your way to get to settlement. You don't have to in either model, but you can. And in litigation, often the court will order it. So if you can't settle and you want to go have a trial, the judge will say, before you come use my time at the courthouse, I would like you to go to mediation and see if you can settle. And in collaboration, if the parties have not been successful getting to complete settlement, they might feel like it would be helpful to bring in a mediator to just have another brain, shake it up, see if they can come up with some more ideas to break through wherever they've gotten stuck.
How common is it to go into mediation? I know you just said that judges will often require it as part of the litigation process.
Yeah, it's very common. I would say back in the 80s, the judges started. In fact, I think my dad was the first judge in Dallas County to require mediation. So he's kind of famous. And once the judges started doing it and everybody had to do it, then we realized how valuable it was and how successful it was. The settlement rate is probably about 85% of cases settle. So people found it to be really helpful tool. So I would say most cases go to mediation. If they're not easily settled without, almost where the clients come in with a settlement agreement, if they have some things they really disagree about, most people do go to mediation.
And is there any scenario, practical or theoretical, where for whatever reason a judge would skip the mediation process? He would say, no, we're not going to do that. We're going to go directly to trial. Or does it basically always go to mediation first?
So what some of the judges will do is they'll say, if you don't go to mediation, you only get 1 hour per side for trial. because they're looking at it as they have limited time and they have an obligation to the taxpayers of their county to use that time as best as possible. So if you go to mediation, you may not need the court's time. So they need to reserve that time for people who really need it. But if it's only going to take you an hour to try your case, then you might be better served by going to trial, because it's not going to take very long. It's not misusing the county's resources. But if you want a 3-day trial, which I usually do, or at least a day, they're going to require you to go to mediation before they'll give you that kind of time.
Now, how, because obviously the sort of new person being introduced in this scenario is the mediator. How is the mediator typically selected? I would imagine that in some scenarios it's mutually selected, but I think I've also heard of judges appointing mediators before. Is that right?
That's correct. So the judge can appoint and name the mediator, but usually lawyers want to pick who their mediator is. So they would ask the judge, hey, we both like so-and-so, we'd like to pick that person. And when you were considering, when I'm the lawyer who wants to go to mediation, I'm considering it, I'm thinking about somebody who has a lot of experience. And we have mainly the mediator you would want in a family law matter, which is divorce and modifications, would be somebody who practices family law or who sat on the bench as a judge. So example, Marilee Lewis in our firm, she was a judge for many, many years on the family district court bench. So she would be a good one. Or myself, of course, because I've done it for so long. But besides us, which obviously we think we're great, but besides us, I can't hire myself, so I have to hire someone else. I think of people who have a lot of experience in family law, because I want them to know what's going on in those courts. I want them to be able to say with some authority, gosh, lawyer XYZ, have you ever seen that judge do that before? To just help the lawyers to give their clients a little reality on some issues. And I also want someone who understands what we're talking about and who has seen a lot of deals struck. So they have some things to offer that maybe we haven't thought of yet.
So it's not just enough that they be a neutral party. You know, like the client's pastor would not be a good pick for me.
No, I mean, I like pastors. I like religious people. So I'm all for the pastor, but he's just not going to understand what's possible and not possible, and the questions to ask to drill down. And you might waste a bunch of time with somebody who's not knowledgeable about family law, because they wouldn't even know what we need to agree upon.
Okay, so now that we've outlined what mediation is, why should people use it? What, in your opinion, are the benefits to it over litigation or, any other method of resolution?
Yeah, one of the biggest reasons people like mediation, me included, is when you settle something in mediation, we type up what's called a mediated settlement agreement. And the mediator usually types it up right there that day. And usually we're in mediation all day. It's a long day. And hopefully we reach an agreement, and then the mediator types it up. That agreement, once signed by everybody, is binding. So the next day, husband can wake up and have buyer's remorse, too bad. Wife can wake up, have buyer's remorse, too bad. They are stuck with it. And that is nice, because you don't want to work that hard to get a deal and then have the other side wake up the next day and say, oh, never mind. It is binding. The Supreme Court of Texas has said more than one time, it is binding, it is binding, it is binding. So even your judge, your district judge, cannot undo your deal. If it is signed, you have a right to judgment, which means the judge has to sign your decree of divorce or your modification order consistent with your mediated settlement agreement. And that is different from, we just reach agreement ourselves informally. If we reach agreement ourselves informally and we don't have a mediated settlement agreement, then you can have buyer's remorse the next day. So that's a big benefit. Another big benefit of mediation is it is a confidential process. So nothing that anybody says a mediation can be repeated in a courtroom later, for example. Nobody can put me, the mediator, on the witness stand and say, tell us what so-and-so said in mediation, how ridiculous they were. No one can talk about the settlement offers. And that is to allow us all to have a bad idea on the way to a good idea and not worry about it. But you need to be able to freely brainstorm and not, worry about everything that goes through your mind. You just blurt it all out, and because it's confidential. So that's a big benefit. And there's other settings that the courtroom is certainly not confidential. Courtrooms are open forums. Anybody can walk in and sit and watch your court. Right now, we have court through Zoom because we're having COVID situation. And people can watch, in most cases, court on YouTube right now. That is not confidential. So having a confidential setting, you don't have to be famous to value confidentiality.
Well, there we are. And sort of a related question, and perhaps it's the same things you've just articulated, but why do you think mediation works as well as it does?
That's a good question. I have several theories. One is that the cases just need focus. The lawyers are busy, the parties are busy, maybe they're trying to settle, but they're sending settlement offers back and forth, maybe by email, and they don't fully understand them. Mediation gives focus on the case. We are all there right now on Zoom. We're doing them on Zoom, but we're there in person or on Zoom, dedicated our time to that day to settle it. And we can ask all our questions, and everybody can explain everything, explain their settlement offers. And just that focus, I think, goes a long way to getting us there.
Well, there we go. One last question, because there's another legal process for resolving disputes with a very similar name called arbitration, which is different from mediation. But I think too many people sound similar, or they don't know what the differences between them are. Could you just briefly explain what the distinctions are?
Yes. So arbitration, different from mediation. Arbitration, your arbitrator, which Marilee in our office could serve as, is a decision maker. They're like a judge. So they're not just facilitating settlement and trying to get the two of them to agree to something. They get to decide. So it's kind of like having a private judge or a private trial. You hire the arbitrator and you have a private trial, and it doesn't have to be viewed by all. And then the arbitrator makes a decision, and it is a binding decision. The only downside to arbitration, if you're going to have a final trial compared to trial with your friendly district court judge, is you cannot appeal an arbitration result up to the appellate court. Whereas if you have a trial with your friendly district court judge, that is appealable to the appellate court. So that's a pretty big deal. You would want to be thoughtful if you think this is a case that might go up to appeal. And you have to pay an arbitrator, and you don't have to pay your local friendly district judge. Now, on the other hand, other positive about arbitration is you're scheduling just your case with this private arbitrator. You're going to go. Whereas the way they handle the dockets in most district courts is they double, triple stack, because a lot of cases settled, as we've discussed. So they overbook the dockets, assuming a certain percentage will settle, and then a certain percentage will be ready and will go. But guess what? It doesn't work out perfectly. So when you're trying your case to the district court, you might show up for court and then be told, oh, sorry, we have too many today, go home. That's expensive. It's not going to come back tomorrow. It's going to come back in a month. And then you have to get ready for trial again. I mean, obviously, some of your preparation will carry forward, but there will be things that keep happening over the next month, and you have to get some of the stuff back in the front of your brain that you need for that trial. So there are some cost savings with arbitration with a private judge, even though you have to pay the judge.
Well, there we are. And I did think of one further question, and this may have been covered earlier, and I've just forgotten about it. But to cover our bases, are there can mediation be used to resolve any family law matter, or only certain ones, only divorces, only certain things like that?
Oh, that's great. So mediation can be used to resolve any family law dispute and any civil dispute. So it's very common also in regular civil cases. So an individual sues an individual sues a company sues an individual, somebody sues the government, somebody sues the Catholic Church, all of that. That is also all going to be mediated most likely.
Okay, well, there we go. Well, that's all the questions that I have. Is there anything else you want to add or fill in that we didn't get a chance to get to?
No, but I enjoyed this, and I think people should consider mediating their cases because I think it will benefit them.
Well, there we go. And if you think you might benefit from a mediation, listeners at home, we can help you with that at the law offices of Duffy and Eitzen. You can give us a call at 214-416-9010, or check us out at duffyandeitzen.com. That's DuffeeAndEITZEN. You can also send us an email at info@d-elaw.com. Thank you so much for listening. I have been Matthew Eitzen.
I am Melinda Eitzen.
And this has been the DFW Divorce Insider Podcast. Take care, y'all.